Hi, I'm Frank McKenna, the Chief Exec and Chairman of Downtown in Business, and I'm delighted to be bringing the Downtown Den on tour because we're in the offices of that fantastic law firm based at the heart of Liverpool, Glenville Walker. And with me today to talk initially about shareholder agreements are Mike Smeaton, who is the Head of Litigation here at Glenville Walker, and Anna Salisbury, who's a partner at the company. So great to see you two today. Thanks for coming along and thanks for sharing your knowledge, your thoughts on this important matter, particularly for SMEs, I would suggest, which of course is shareholder agreements. So Mike, just give us a flavour of the sort of issues that SMEs, business owners, shareholders tend to come to Glenville Walker with.
Yeah, well, I mean, we call ourselves commercial litigators, but it's such a broad term that it encompasses almost any type of dispute that you can imagine that a business or a business person might find themselves involved with. Those are the sorts of things that me and Anna are dealing with, and the rest of the team are dealing with on a day-to-day basis. So when we knew that we were coming on today, we kind of had to think about what sort of stuff is likely to be most relevant to Downtowns or the members. What might people find useful? What might they like to know that we're here to deal with if they need us? And one of the topics we kind of settled on was shareholder disputes, because chances are, if you're in business, particularly if you're a sort of smaller or SME sized business and you're an owner of that business, then you're a shareholder. Very often you'll also be a director of that company with one or more other people. And it's that intersection between shareholder and director and the different obligations and duties and rights that those two roles encompass that can very often give rise to disputes. And so it's a large part of the work that Anna and I and the rest of the team are doing here. It is related to shareholder matters, director disputes. And it's such a broad range, it can be anything. I mean, if you imagine that you've set up a business, the early stages of that business are quite rightly focused on, how do I get this going? How do I make as much money? It's not, what happens if this goes wrong? What happens if I fall out with my mate who I've set the business up with, or with my spouse, or with my brother? But by the time those fallouts happen, and unfortunately they very frequently do happen, it's often too late to do anything about it. And that's where Anna and I tend to kind of come in to help resolve matters. But there are certain things that businesses and business owners can do to sort of guard against that before it happens. So hopefully that's something that people might find interesting to hear about.
Yeah, I mean, I've heard so many tales, Anna, of people who've gone into business in good faith, usually with a friend, sometimes with, as Michael says, a spouse or a brother, and it goes wrong because they haven't got a shareholder agreement in place. So do you simply deal with disputes, or do you do shareholder agreements for people before they actually go into partnership?
Well, our corporate team will deal with the shareholder agreements and drafting that and discussing that with the shareholders and the directors to determine how they want to hold the shares, who holds the majority. So our corporate team would deal with that. But quite often we deal with the disputes on a day-to-day basis, Mike and I, of when they've fallen out, directors have fallen out, shareholders have fallen out. And quite often it may be 50-50 shareholders, and that often is a big problem, really, and we get what we call deadlock because there's very limited options available to the directors. But our corporate team would advise the directors and the shareholders of that before hopefully before they agreed that shareholding percentage, so that they understood what could go wrong before it goes wrong.
And what's a typical example of some of those things that might go awry? The sort of things that people come to you and say, this isn't working anymore, can you sort this out for us?
I think sometimes it's different vision. Different directors have different vision of where the business is going. Some people are quite happy plodding along and then some people have got bigger ambition. Family fallouts, maybe one director spending more money than another director, and the other director's not happy with that level of spending, or general fallouts really.
And when that happens, Michael, are you in a situation initially where you will try and counsel them through that issue? Or is it a case that by the time they get to Glenville Walker, it's usually past that and it is getting into the nitty-gritty of, okay, how do we resolve this through legal means?
Yeah, I mean, as litigators, I sometimes say that we're the solicitors that absolutely nobody wants to come and see. So by the time...
You're like the divorce solicitors of business.
Yes.
Well, exactly, and
Yes.
that's another thing we often say is that actually shareholder disputes are a little bit like a divorce, because particularly when you're dealing with SME businesses where those shareholders are the directors, they're running the business, it means that much to them that the fallouts become bitter and twisted really quickly, and the range of things that can cause a dispute is wide, as Anna's just said. I mean, the classic example, I suppose, is family-run business or business that's been set up between pals. It's gone swimmingly for as long as it has, and then you might get one shareholder taking a back seat. The other shareholder thinks, crikey, he's not pulling his weight. I want him out. Yeah. By the time it reaches us, it very often is too late to sort of mend that fallout, and you're left sort of trying to pick up the pieces. But you'd be surprised at how few businesses have shareholders agreements in place. And some people might be watching and listening thinking, well, what is a shareholders agreement? Because people who are involved in the running of a company might think, well, we've got articles of association, we had to do that when we set the company up, and that should be enough. A shareholders agreement is something different, and that's a private agreement between the shareholders about how their relationship is going to be managed, what their obligations and what their rights are, and it can provide for any number of things. But the sort of things that most commonly give rise to disputes we see are what happens to the parties' shares after a fallout has happened. So, if you imagine that we've decided between you and I are in business, we've decided between us that I need to go because it's not working. I can't just up and leave. I've still got the shares in the business, and you want those back. You don't want somebody within the business who's not doing anything anymore. How do you go about doing that? Well, that's the sort of thing that a shareholder agreement would generally be designed to cater for. It's not adequately catered for, generally speaking, by articles or by the law in general.
And it will deal with who buys them, who values the business, those type of things as well. Yeah. And the specific detail will be set out in the agreement.
Yeah, because I guess that's a big area of dispute, isn't it? How much are your shares worth? If you're looking to walk away from the business, or there's been a decision made that a split is required, the valuation is crucially important. And if that's not already set down in stone, then, as you say, it's inevitable it gets into a dispute.
Yeah. It's the classic scenario is that, well, one party's leaving, but they can't agree on how much those shares are worth. And unless you've agreed a mechanism beforehand, because, of course, by the time you've fallen out, it's too late to think that you're going to get agreement on that sort of thing. Unless you've agreed it beforehand, you're in a pickle. It's a little bit like, well, you've got that pen there. That looks like a nice pen. I'll buy it from you. And you say, I'm not selling it. Or I'll say, well, I'll give you 20 quid for the pen. It's not worth that. I can't force you to accept that. And that's frustrating for me. I'm willing to pay more than the pen's worth, but you're not willing to part with it. That's a silly example, but the same principle applies to shares as it does to any other asset that you might own. So that's the sort of thing that we would encourage people to try and make sure they've bottomed out long before any dispute rears its head. A mechanism for how those shares would be valued, how they would be sold. And it could be who do you sell it to as well. I mean, dealing with a case at the moment, obviously, on an anonymised basis, but very, very successful and profitable family business. It's been in existence since the 40s or 50s, I think. And the shareholders have always operated on a trust basis whereby once it's time for someone to pass on their shares, or if they die, they stay within the family. And that's always happened, and everyone's always done the right thing. And that's fine until it's not fine, and somebody kind of doesn't stick to that, gentleman's agreement, if you like. So in this case, we have a shareholder who's deceased and has, unbeknownst to the other shareholders, left those shares, which are worth an awful lot of money, to his new partner. And there's no shareholders agreement. The existing shareholders don't want the new partner in the business because they know nothing about it. They can't help to run it. It just isn't going to work. So the difficulty that we're left trying to sort out is, well, how do we get through that situation? Now, there will be a solution for them, but it's a solution which is going to be far more complicated and probably costly than it would have been had that agreement already been in place. And I sometimes say that it's worth thinking of it like an insurance policy. You've got a house insurance policy. You hope that you never need to refer to it, but you'll be glad you've got it if you do. Yeah. The ideal scenario is that the parties reach agreement on shareholder matters. They've got a document which sets them out, and they can just toss it in a drawer, and it sits there for 20 years. Yeah. Nobody ever needs to look at it. But you'll be glad that you've done it if you need to rely on it. And although people don't want to spend time or money, particularly in the early stages of business, going and seeing lawyers and paying fees, it's one of the biggest examples of sort of false economy that we see, trying to do it on the cheap. It really is worth doing that as soon as possible, at the outset of your business relationship. But any time is fine, so long as you haven't already fallen out. Yeah, exactly. Yeah.
I think it was a great point that you made earlier, Michael. The first thing that people are thinking about when they set their own business up is, well, it's an exciting time for a start. Then they're thinking about how they take the product to market. How do we market? How do we sell? How much money are we going to make in year 1, 2, and 3? And the last thing on the mind, in a sense, is going to be these complexities that you've referred to. And what you're saying clearly is, look, this could be short-term pain in terms of a bit of cash to set the shareholders' agreements up, but long-term gain if you do get into any dispute.
Yeah.
That's
Absolutely.
basically what we're saying to people, isn't it? You're better to do this as soon as you possibly can, rather than wait to get into a situation where you're in dispute. And what the costs, I guess, can be
astronomical.
Quite big.
I mean, I was supposed to have a trial next February. Thankfully, we settled it at the end of the summer, but it was a 15-day trial listed in Manchester, and the costs of trial alone were upwards of 600,000 for each party. So we're talking big money, big cost, and that's one of the reasons why I think both parties resolved the matter, because they were very mindful of the costs of trial, and then it's the risk of losing and paying the other side's costs, which could be catastrophic for some individuals.
Gosh, yeah. So let's just get this boiled down into a nutshell and mix some metaphors there. But you're basically saying, even if you've been in business for 10 years and you've been happily working in partnership with your fellow shareholders, it is never too late to actually seek some legal guidance, seek some legal advice, get that shareholders agreement in place, because we just don't know what's around the corner. I mean, the case that you've just mentioned there, Michael, who could have foresaw that?
Yeah,
a shareholder just leaving his shares to somebody that nobody else in the firm knows. And as you say, that causes obvious challenges.
Yeah, well, absolutely. I mean, Anna's referred to the costs there. That's, there's obviously a scale based on sort of how complex the dispute is, how big the business is. But the other thing to remember is that for as long as the shareholders are in dispute with each other, and particularly where those people are the directors as well, the business is suffering. Business is not doing what those people are not doing what they should be in the business and driving it forward.
Because they're focusing on their dispute,
bickering with each other. So they're hugely disruptive to business, hugely costly to try and sort out legally as well. So we're not saying that a shareholder agreement will guarantee that there are never any disputes. Of course, it won't. But they do make it a heck of a lot simpler and more cost effective to negotiate through those difficulties should they arise. that case I mentioned before is just one example. We see examples ranging from small businesses, two-person, 50-50 co-shareholder directors, right up to much bigger scale. One of the cases I'm dealing with was featured in The Guardian last week. High-profile defendants. The money involved is eye-watering, and the costs involved are eye-watering. And so whilst we're always going to be focusing, if we can, on trying to reach a resolution that doesn't involve court proceedings, or at least a full-blown court trial, inevitably that's sometimes the only solution for people, and things could have been made so much simpler had they just looked at it a little bit earlier. And as you say, take that short-term pain in the form of having to pay a level of costs which, with hindsight, will be a drop in the ocean should the worst happen. So, it very much is a case of look at it now, and as you say, you could have been in business 10 years. It doesn't matter, and in fact, you may already have a shareholder agreement, but it may be worth considering whether that is still fit for purpose.
Because things progress and move on.
It needs to be updated.
So you might have had the foresight to enter into one when you started out in business. Since then, the business might bear no resemblance to what it did then. It might be 10 times bigger. You might have other shareholders who've come on board. And so it's always worth considering, like you would with your will, or something, considering whether it remains suitable for what your aims are, what direction the business is going in. And that's particularly the case, I would say, if the business is going through a period of growth, or if those involved in the business are potentially starting to turn their mind towards succession or sale or something like that. All of those big milestones in the life of a business, they should all be indicators for people to have a look at this sort of thing and make sure that the documentation and the corporate governance is up to speed and fit for their purpose.
It's a great framework to have in place, a shareholders agreement. I get what you're saying, Michael, in terms of saying it might not always be able to resolve everything, but at least, as I say, you've got a framework to look at. And just one final point from me, because you've just triggered something. In terms of people who are in business together for a long time, there is often, isn't there, a difference of opinion or a difference of motivation. One of them decides, actually, we're in a good place, great time to sell. And the partner's thinking, I love what I do. I just want to crack on and continue. And then you get to that point, exactly what you were saying earlier, Anna. Who values the business? Who decides whether they should exit? Or so are those sort of things that you guys can advise on in terms of putting that into a shareholders agreement, whereby you get to that point where we can have an easy resolution of the problem once we get to that state?
Yeah, absolutely. Glenville Walker have got lots of experience in those type of shareholder agreements. Again, our corporate team would advise on them, probably with some assistance from the litigation team to foresee any potential litigation slips or risks, and just to create some absolute certainty or more certainty should there be any litigation or any disagreement or fallout in the future.
Brilliant. Okay. Well, I think some great tips and tricks there that we will pass on to our members, obviously. And I think, the important points that have been drawn out today really is shareholders agreements are something that are a necessity, not a nice to have, because as you've heard from Anna and Michael today, you can always have unforeseen circumstances that come along and end up tripping you up. So rather than get into that situation, why not come and have a chat to the guys here at Glenville Walker and see if they can sort a shareholder agreement out for you, or indeed update the shareholder agreement that you've probably stuck in a drawer 10 years ago and haven't looked at since. Anna, Michael, thanks very much for your time, and hope to see you again soon. Thank you.